Okay, we have some other presenters and some other special reports, and so we're gonna go through those before we get to the email security training, starting with the chair of the MCLE board, who's gonna give the annual report for the MCLE board. Mr. Alberstone.
Thank you. Thank you very much for having me. And it's a pleasure to be here and a pleasure to be back. I presented to this board. I had the honor of presenting to this board back in 2019. And so I'm glad to have the honor of being back here again today. I apologize that I could not be here in person. I had hoped to be, and I have to do this by Zoom. I also want to thank the Board of Governors for your support for the recent amendment concerning the CLE requirement for diversity, inclusion, and elimination of bias, which, as you know, was approved by the Supreme Court in the previous period. And because it's previously been approved, in many ways, this presentation will be somewhat less dramatic than it might have been if that were still pending. It's sort of business as usual, but I'm glad to be here. My presentation will be brief, and I will follow the 5 questions that were provided to me, and I think to other board chairs as well from the Board of Governors. I just want to note that thankfully, Adeline Shea, our colleague, is with us here today, and she may jump in or virtually kick me under the table if I get anything wrong, say the wrong thing, or if there's a hard question that I can't answer and I start to look up at the ceiling. So with that in mind, let me just jump in. The first one was, please provide an overview of the purpose of the entity, authority, composition. And I'll start with authority. Our authority, you probably all know, but our authority is from APR 11 D2. We are appointed by, our members are appointed by the Supreme Court. Our composition is 6 WSBA members and 1 community member. And the purposes of the MCLE board are set forth in some detail in APR 11, but just to sort of summarize them in a general way, kind of the workaday aspects of it are we accredit courses and educational programs and activities that satisfy the requirements of the MCLE rule. We consider member petitions and appeals and also sponsor petitions and appeals, which may relate to whether an activity or a particular course is sufficient for MCLE credit in the state. Or in the case of members, it may also relate to questions of hardship. A particular member may have a reason for petitioning the board to say they couldn't fulfill the requirement and need an extension, or they need a waiver of a late fee or whatever. And so that's kind of the things that we do. And beyond that, as this board knows, we suggest amendments and also promulgate regulations to APR 11. Amendments, of course, are reviewed by this board before they go to the Supreme Court and must be approved or rejected, as the case may be, by the Supreme Court. Some of the things I just identified are delegated, and under Rule 11 can be delegated and are delegated to staff at WSBA. So although we sit outside WSBA, we are not the WSBA CLE department. We do not create CLEs. Although we're outside of WSBA in that sense, we couldn't possibly function without the staff doing most of the hard work for us before harder questions or policy questions come before us. So for example, whether or not a course satisfies the requirements of the MCLE rule, and particularly if it's a national course, whether it's sufficient for Washington State, or whether an activity by a member satisfies the MCLE rule, or the waivers and appeals decisions, those are all made in the first instance by staff and then come before us if there's a hard question, if the staff isn't sure, if it doesn't fit easily within their decision matrix, or if the member or the sponsor wishes to appeal. Second question was support for the WSBA mission. So we believe that we're all passionate about continuing legal education. You wouldn't be on the board, you wouldn't apply for the board if you weren't. Certainly I am. So we believe that continuing legal education is hugely important with respect to the integrity of the legal profession, serving the public, and in general, holding ourselves, meaning the members of the WSBA, to the highest standards, both of integrity and skill. So, we're passionate about it, and we believe it's crucial. And to jump in, then what are the projects that we have going this year? And again, let me take this opportunity to thank you for the recent amendment, your support for the recent amendment to APR 11. These are a little less dramatic. We have a work group to review and make a proposal concerning law clerk tutors and MCLE credit. What that's about is, you may be aware that there's an alternative to law school that allows an individual to be tutored over a period of 4 years in a very structured manner that can eventually lead to membership in the bar, and without ever going to law school. And it's sort of kind of the modern version of an apprenticeship program, as it were. The tutors are not professors, and they are unpaid. We think, we believe at the MCLE board that it only makes logical sense and common sense to provide them with credit, the tutors that is, provide them with MCLE credit for the hard work that they do. They have to create and review exams for the individuals that are being tutored every 6 months, and it's a fairly intense position to be a tutor. But not assuming our own conclusion, we have a work group that will make a recommendation at our January meeting concerning whether or not tutors should be granted MCLE credit for the work that they do, and under what conditions, and what the specifics might be, and prepare some sort of report that we can present. And potentially, in terms of timing, potentially there may be we hope, we anticipate a GR9 cover sheet by early October on the subject. And at that point, the Supreme Court will either post it for public comment or possibly simply reject it. And if all goes forward and MCLE credit is to be granted for that work, it can be effective as early as, or no earlier than, September of 2023. Then COVID has presented as the second kind of group of projects or work, let's say. COVID has presented us with some interesting challenges. As you know, the MCLE reporting requirements were extended by the Supreme Court for a year, and they're coming up now. So the extension goes to 12/31/2021 from the previous group, from the previous section, and they must report by February of 2022. So what that means is there's a lot more work coming ahead, both for the WSBA staff and for our board in terms of review of petitions. The WSBA staff, I know, is working hard on updating databases to automate the review of LLT and LPO MCLE fulfillment. Beyond that, we anticipate that the extension period will roughly double the staff work. And of course, it will also greatly increase the number of petitions that we see, and both because it's a larger reporting period, but also because, quite obviously, many people have suffered mightily under COVID and will no doubt want to petition for hardship extensions, et cetera. So we are anticipating sort of a flood of that. And then beyond that, we are looking at an increase in petitions and certifications with respect to diversity, inclusion, and elimination of bias programs. The certifications for our members are open in July, and activity commissions applications can be submitted thereafter. But it doesn't actually come up as a requirement until the fall. And then beyond that, just to run through it, because I know we're a little off schedule, jump in anytime and feel free to interrupt me with questions or challenges as you see fit. I like to say one of the perks of being on the MCLE board is that we get to audit courses. But it's also something we're supposed to do under Rule 11. We are like those who want to make New Year's resolutions. We, in this particular year, 2021 to 2022, have all undertaken to fulfill our requirements to audit at least twice in the coming year and prepare the appropriate reports, et cetera. And auditing is a crucial part of what we do. It's how we have a direct connection with the quality of MCLE courses and MCLE sponsors. Additionally, we are making a commitment to increase diversity on our own board. And we do that through outreach. We anticipate doing that through outreach to bar groups. Diversity here includes geographic diversity as well as other diversity criteria. So we want to not only avoid having a board that tends to be homogeneous in terms of ethnicity or race or whatever, orientation, whatever it might be. But we also don't want a board that's all from Seattle or from the greater Seattle area. So we are doing our best to do outreach so that as new seats open up on the board, that we increase the diversity of the board. Finally, I jumped ahead a little bit a moment ago, but just to dive into the new Rule 11H amendment, diversity, inclusion, and elimination of bias. The new rule is in effect as of September 2022. The first reporting group will be 2023 to 2025. So part of our role is providing direction to CLE sponsors, and this has already come up for us, on what satisfies it, what sort of course and what are the criteria to be applied. As a general rule of thumb, our approach has been and is that courses that are not designed nor intended for legal professionals are not eligible for inclusion under APR 11H. So we are looking for courses that aren't simply, let's say, the HR training that might occur at Amazon or Microsoft, or which isn't particularly intended for legal professionals, or courses that are let's say, from a business school program or whatever. We're looking to encourage, and we want the new requirement to be meaningful. And the way to make it meaningful is, we believe, is to ensure that it is applicable and relevant to legal professionals in the state of Washington. Beyond that, here's where I have to pause and read carefully. We are participating, along with other boards, with the TaxiCab initiative. That stands for Task Force Administering Xenial Involvement with Court-Appointed Boards. Xenial with an X. It's created to begin collaborative discussions with the Washington State Supreme Court and to coordinate efforts to administer court boards and facilitate cooperation and sharing of information between the court and the WSBA on issues related to substantive, fiscal, and administrative concerns. In short, making the various court-appointed boards less siloed and more cooperative with each other, and to coordinate how we all work. So the next question on the list, forgive me if I'm running along too fast. Again, feel free to interrupt. The next question on the list was our long-term goals. And our long-term goals are essentially to continue to encourage and support MCLE compliance, ensure that CLEs are meeting the needs of both the profession and the community, including as those needs evolve, and responding to members and sponsors' needs in a consistent manner to encourage the highest possible standards. Work cooperatively with other boards, of course, and all the while following the guidance and direction from the Washington State Supreme Court. And the final question is, how can the Board of Governors assist? And our answer is, well, certainly support for free and low-cost CLE programming through the WSBA. Though we are not the WSBA CLE department, we believe that the free and low-cost CLEs that are offered through WSBA are crucial, both at the fairness level as well as at the practical level of making it easier for people to actually fulfill their CLE requirements rather than petitioning for reasons to be relieved of the compliance requirement. If the real reason, whether it's articulated or not, is simply that it's too expensive or just too difficult to fulfill CLEs through the for-profit providers. And then beyond that, the crucial thing is, much like a character out of Gulliver's Travels, although we are separate from WSBA in a sense, we are completely dependent on the WSBA staff and can't function without them. So in general, support for WSBA staff. Thank you.
Thank you, Chair Alberstone. Are you going to have anybody else present? Nope.
Not unless Adeline would like to say a few words herself.
No, that's okay. Thank you.
Okay, thank you very much. Any questions for Chair Alberstone? Past President Cicchetti.
Not a question, but a expression of gratitude. We've been working with Robert Mcle as a representative on the taxi cab task force, and we've had several meetings, very cooperative meetings, very congenial meetings, working toward what you said just a few minutes ago, which I'm going to steal, less siloed working environment, which I think is a good way of expressing what we kind of like to bring the WSBA and the boards together so that we're cooperating and working better, and we're less tension on our staff to be pulled in different directions. And like I said, it's been very successful to date, and we look forward to working with the MCLE board and the other boards on into 2022.
Thank you. I'll just say that Robert is passionate about the work on taxi cab and is a tremendous leader in that regard.
Any other questions? Again, thank you very much, Chair Alberstone and MCLE Manager Shea for being present for this presentation.
Thank you. It's my honor to be here.